The Fourth Circuit says the DEA is wrong. Hey, I'm Morgan Davis. I'm a health and wellness attorney based in Raleigh, North Carolina, with a focus on cannabis. Let's talk about how to keep your business protected and thriving. Recent case out of the Fourth Circuit says that the DEA's position on synthetic cannabinoids is wrong. Everyone in the hemp industry is celebrating. A little bit of background. Recent case in the Fourth Circuit, Anderson v. Diamondback, is a case where an employee was fired by Diamondback, their employer, for testing positive on some drug tests. The company has a zero tolerance policy for the use of controlled substances. She submitted to several drug tests and tested positive for marijuana or THC in several of them. Was then terminated. She filed lawsuits saying that she was wrongfully terminated for a variety of reasons, one of which is that she was lawfully using hemp products under North Carolina law, and therefore her termination based on positive drug tests was wrong. Ultimately, the Fourth Circuit doesn't agree with her and finds in favor of Diamondback. But in their analysis, they go deep into the analysis of what is a legal hemp product and what is not a legal hemp product. We've only seen one other circuit court go into this level of analysis, which is the Ninth Circuit in the AK Futures case. But the Fourth Circuit goes further. Here, they weighed in on the issue of whether or not a hemp product is defined by a cannabinoid concentration of Delta-9. They find clearly that the 2018 Farm Bill, which legalized all hemp products that we know of these days, only has Delta-9 THC as the marker. Basically, it says the federal Farm Bill is not ambiguous. It's very clear that if it contains no more than 0.3% Delta-9 THC by dry weight, it is hemp and it is legal. Because it's not ambiguous, the Fourth Circuit and all courts and the law does not have to give in to the DEA's assertion that other cannabinoids like Delta-8, THC, THC-O are illegal. So how do we get to this whole conversation? Part of Anderson's argument is that the products she was taking were a combination of Delta-8, Delta-9, and HHC and THC-O. Diamondback argues that because the DEA, in at least one letter, says that THC-O is a controlled substance and a synthetic cannabinoid, that therefore her argument that her products were legal and she should therefore be exempt from termination or was wrongfully terminated is invalid. So going back, we've talked several times about the DEA's various positions on various cannabinoids and this whole synthetic versus naturally derived argument. It's a super popular argument these days that legislatures have glommed onto. We see all sorts of legislation coming out about it. And it's also a very popular argument that the regulated cannabis market makes about hemp, saying, oh, they're making all these synthetic cannabinoid products. They're dirty, they're gonna hurt you. And some of that may be true. But the way that some of these cannabinoids are made, most often through the isomerization of converting CBD into Delta-8 or follow down the line of some other cannabinoid, is not in and of itself synthetic, is what the Fourth Circuit basically says here. The DEA has issued many opinions previously saying, well, the only thing that matters is naturally derived. That's the only thing that the Farm Bill exempted. Fourth Circuit says no. Fourth Circuit says it's very clear that the only thing that makes hemp hemp is the Delta-9 THC concentration, and nothing else matters. They go on further to say that because it's not ambiguous, they don't have to give deference to the DEA. They don't have to say, hey, DEA, we take your word for it. We give you deference as the agency over controlled substances. Instead, they say we can choose the better authority. Not just to say the DEA is not the only authority, they say they're not the best authority when it comes to this argument about synthetic versus not synthetic, or legal versus not legal in terms of the Controlled Substances Act. Instead, they cite to the National Institute for Drug Abuse, which talks about the standard turning on a lab-made cannabinoid. So when we talk about synthetic versus semi-synthetic or non-synthetic or naturally derived, the common understanding up until this whole issue that's been created in hemp is that synthetic cannabinoids were completely man-made in a lab and that they mimicked the chemicals in cannabis but often had very different side effects. Well, most people would say that products with Delta-8 and HHC and THC-O and THC-A, while they may be created through conversion outside of the plant, they are often derived from CBD, which is derived from the plant. So it's not completely lab made. They are converted from plant material. And in addition to that, they often have a similar effect to Delta-9 THC or the consumption of hemp or cannabis. Maybe slightly different, but not wholly different. The way that most synthetic cannabinoids prior to this conversation were believed, the kind of effect they were believed to create was very, very different than the cannabis experience. Conclusion, this is a significant ruling for hemp. Now, it doesn't mean that you can say all hemp products are legal. You can't say that. The Fourth Circuit says, in terms of federal law, the only thing that matters is the Delta-9 standard. In terms of North Carolina law, which mirrors the federal law, the only thing that matters is the Delta-9 standard. So if you're in a state that mirrors the federal law, the only thing that matters is the Delta-9 standard. However, as we know, there are lots of states who have implemented their own regulations, whether it's a total THC standard or a milligram cap, or they have in fact banned what they've determined to be synthetic cannabinoids. That state law is good until it's overturned. So don't go running around thinking that this is a pass. It's not. But it is a significant argument in favor of the idea that this whole synthetic versus naturally derived conversation is pretty much moot, and definitely in favor of the idea that the DEA's position, which has wavered a lot, is not the best authority when it comes to what is hemp and what is not hemp. What does this mean for hemp businesses? If you're a hemp business who's producing products or selling products with any of these synthetic materials in them, you still have to comply with state law. But under federal law, it seems very clear now that you shouldn't be concerned. Does that mean that the DEA won't respond? No, it doesn't. But the Fourth Circuit gives you a big leg to stand on should you have that question in your head of, am I violating federal law? In addition to that, in states where this conversation is still happening about naturally derived versus synthetic, and you have the opportunity to advocate for yourself, this is a good argument on behalf of the idea that that bifurcation doesn't matter anymore. If you're concerned about what types of products you're selling and where they fall in this conversation and what you can do to ensure that your products are in compliance with where you're selling them, give us a call. We'd love to help you.